So Leslie will be delivering the inaugural talk for this year, public lecture, in a series that I would like to ask you to excuse me for taking a few minutes to introduce, because I would like us to place the fascinating speech that is going to follow, and that's what you come for. But I would also like us to attempt to contextualize and to place that in the wider context of the public lectures, the themes that we are going to explore in this public lecture series. I genuinely believe that the UK is not remotely a corrupt country, nor do I believe that our institutions are corrupt. Boris Johnson, COP26. The fact that it needed saying at all is a signal of how low public opinion of politicians may have fallen, explained Tim Ross in the New Statesman. This government is not corrupt, urges us Boris Johnson to accept. But crisis after crisis, scandal after scandal, U-turn after U-turn, the position becomes quite indefensible, untenable, unsound. And people begin to ask, quite rightly, has this government gone morally bankrupt? Morally bankrupt on equality, on Brexit, on human rights. I'm mentioning just these three themes because these are the themes we will be exploring in the first part of our Goldsmiths Law Public Lecture series that we have the immense pleasure of launching tonight, while confronting a new winter of discontent. Nearly 18 months since the murder of George Floyd, has this momentous global event, which had deafening echoes of racial injustice closer to home, has it brought the much-needed change that we were promised? Is the more specific question that tonight's lecture addresses. And there could not be a more powerful voice than that of our most distinguished visiting professor in law, Professor Leslie Thomas, to deconstruct it in the forensic, exhaustively meticulous way that we have become accustomed with, through his Gresham lectures, for instance, and the invaluable opportunities that we have had to connect with him at Goldsmiths, even though virtually until tonight. The Black Lives Matter protests are a distraction, we read in the Times. They have helped sow division between the races. The words of Catherine Bilbasley. I don't know if you're quoting here in your presentation, by the way. But this October, she was appointed chair of the Social Mobility Commission. How not to quickly deduce then that our politicians have never really intended to challenge the status quo on equality. On other key matters too, on Brexit and human rights, conservative politicians have shamelessly continued to embrace fiction, populist Eurosceptic propaganda, even now that we have left the EU. Trade barriers in Northern Ireland are of the EU's doing, we hear. We've been given a bad deal on fisheries, they complain. We're not going back to the same old broken model with low wages, low growth, low skills, and low productivity. All of it enabled and assisted by uncontrolled immigration. Boris Johnson began at the Conservative Party conference this October. It was, of course, the first time that we were hearing of this as a political objective of Brexit, a narrative that was conveniently constructed on the spot, out of thin air, to explain the unexplainable, such as mile-long queues, the many hours spent on them outside petrol stations, even the dead of night, and mobilizing the army to perform the essential, or the continuously empty shelves in our supermarkets, in the unfolding staffing crisis in construction, in hospitality, and farming. The crisis in the abattoirs, where we are unable to slaughter pigs, and in our hospitals, where doctors are frustrated in their superhuman efforts to save lives. People are dying in ambulances outside A&Es, and more than 160,000 a year are coming to harm because of long delays, The Guardian reported yesterday. All this, despite Brexit flying in the face of economic logic. The Office of Budget Responsibility now predicts that Brexit will do twice as much, I repeat, permanent scarring to the economy, 4% of the GDP, than COVID. The only way to boost economic growth is by reversing hard Brexit, wrote former Cabinet Minister David Gauke in the New Statesman last week. So, faced with such chronic, devastating crisis, cultural, economic, socio-political, institutional, cultural, should we be really even attempting to draw analogies with the winter of discontent? Or is this rather a case of years of governmental contempt for decency, dignity, and common sense, all replaced by political opportunism and empty, even if sometimes successful, slogans? To legal experts, future legal experts, the law students with us in this room, and seasoned experts, also in the audience tonight, nothing will perhaps speak more clearly to this rapid collapse of a system of political values that should be at the center of government than the government's renewed attacks upon our human rights and our human rights legislation, more specifically the Human Rights Act. I can tell you that under this Prime Minister, before the next election, we will overhaul the Human Rights Act. Dominic Raab, at the Conservative Party conference in October. I'm proud that we have a British Supreme Court, and I don't think it should take orders from the European Court of Human Rights, from Strasbourg. He added, is the same Supreme Court that the Conservative government has attacked en masse following the prorogation judgment, of course, or the Article 50 judgment back in 2017, for that matter. Is the same legal nationalistic narrative of not taking orders from Europe that they are resorting to, with the aim of unraveling the key mechanism for the protection of human rights in the UK, the Human Rights Act, at a time when they should be reinforcing individual rights to guarantee us protection from crises that the state is responsible for. Inequality, harm to health, in the post-pandemic context, but also in our rivers and seas, where people are swimming on shoots, and to prevent the continuous disruption of routine activities of everyday life, as a result of this psychosis with the alienating practices of hard Brexit, the consequences of which we are only just beginning to witness. Everyone on those boats wants a new, better life in the United Kingdom, and that's understandable, as this is the best country in the world, wrote Tom Tugendhat in the Mail on Sunday, with reference to refugees crossing the Channel. From where we are observing tonight, there is much work to be done to ensure this government has people's interests at heart, let alone being the best country in the world, if there is ever really a need for such a narrative of superiority to other nations. Our winter of discontent may be much more nuanced than that of 1978-79, but the threats it presents us with are multifaceted and far more wide-ranging in nature. We're fighting for the psyche of this country. For our university too, there could not be a more urgent time to engage with this fight. Social justice, equality, and human rights go right to the heart of Goldsmiths' historic mission, right to the heart of the modern vision for our Department of Law too. Intellectually, though, the government has little sympathy for these fundamental values. Closer to home, at a pure political level, the government's levelling up agenda has so far translated into a £2 million cut to central funding to Goldsmiths, because of our location and because of our academic offer. We're doing arts, humanities, and social sciences in London. The government is not thrilled, I must inform you. With our home borough of Lewisham being among England's poorest areas, the withdrawal of this funding looks more like punching down than levelling up, has noted our warden. Brexit, COVID and the governmental propaganda that tarnishes universities as establishment institutions for the elites has brought unprecedented crisis in higher education institutions more generally. It is crisis that we must confront also here at Goldsmiths, but job cuts in our humanities departments cannot be the answer. This is a winter of discontent for our cherished institution too, and we must take the opportunity to express our deepest support for all colleagues that may be affected, academic and administrative staff alike. I arrived at Goldsmiths in May 2018, and we immediately set upon creating a vision for a Department of Law that would live and breathe justice, equality, and human rights. The launch of this inaugural public lecture series, coupled with the launch of an annual human rights lecture in 2021 and an annual criminal justice lecture 2 years before that, mark our desire to pursue these values through synergies with our local community, with external partners such as Garden Court Chambers, who have supported tonight's lecture, and with the wider public. We have also conceived it as a platform for showcasing the crucial work that our eminent visiting professors and academic members of staff do to influence public policy. It is our hope that conversation here will inform and empower, further empower, and strengthen your work. I'm delighted that we are kickstarting these lectures with Professor Leslie Thomas QC, who we have had the privilege to appoint as a visiting professor in law here in September 2020. Professor Thomas, a former joint head at Garden Court Chambers and the first Black Gresham Professor of Law, is a preeminent authority in the UK, the authority in the UK on racial equality in the criminal justice system. His pioneering work in deaths in custody has affected so many lives of all those who suffered devastating losses of loved ones, and of all those who may have enjoyed the added protections that were the direct result of his pioneering legal activist work. Grenfell, Hillsborough, Mark Duggan, they speak volumes about Leslie's inspirational human rights-based work and his leadership on racial justice. Leslie, we are thrilled to open our inaugural lecture series with you tonight. The floor is yours. Thank you.
Thank you.
There is no such thing as race. None.
Really?
There's just a human race. Scientifically, anthropologically, racism is a construct, a social construct, and it has benefits. It has money can be made off of it, and people who don't like themselves can feel better because of it. It can describe certain kinds of behavior that are wrong or misleading. So it has a social function, racism. But race can only be defined as a human being.
If the racist white person, I don't mean the person who is examining his consciousness and so on, doesn't understand that he or she is also a race, it's also constructed, it's also made, and it also has some kind of serviceability. But when you take it away, I take your race away. And there you are, all strung out. And all you got is your little self. And what is that? What are you without racism? Are you any good? Are you still strong? Still smart? You still like yourself? If you can only be tall because somebody's on their knees, then you have a serious problem. And my feeling is white people have a very, very serious problem. And they should start thinking about what they can do about it. Take me out of it.
You don't think you will ever change and write books that incorporate white lives into them substantially?
I have done.
In a substantial way?
You can't understand how powerfully racist that question is, can you? Because you could never ask a white author, when are you going to write about black people? Whether he did or not, or she did or not. Even the inquiry comes from a position of being in the center
And being used to being in the
and
center.
being used to being in the center.
The majority, over 75% of black people in the UK, do not believe their human rights are equally protected compared to white people. This is a damning indictment of our society and must be addressed as a matter of the highest political priority. Quote from the Joint Committee on Human Rights, Black People, Racism and Human Rights in November 2020. Although the issue of fair treatment for black people is a much broader issue than the criminal justice system, the fraught, volatile history of policing and the criminalisation of black communities in the UK offers a depressing but necessary starting point. Policing. Over the past 18 months, policing has received global attention. Sparked by the brutal murder of George Floyd, we saw an emergence of critical discourse on racialised policing, policing by consent, and defunding the police. As the Institute for Race Relations said, the death of George Floyd, quote, recalled and coalesced with the police brutality that has taken place across the UK, both historically and contemporary, with some particularly high-profile cases of black experiences of policing gaining attention in 2020. In the light of this, and refusing suggestions that racism and police violence are only a US problem, the UK is not innocent emerged as a popular slogan during and beyond the protest. Critical conversations have long been held, but there appeared to be a newfound support by masses, what many thought would be a racial reckoning globally. At the same time, the world was hit by COVID, itself triggering swathes of conversations about government power, the curtailment of human rights and civil liberties, and whether the use of police forces to police a health crisis was appropriate. Hopes by many that a new dawn was on the horizon were quickly tempered after the policing approach in the first 6 months of the pandemic, alongside ushered through emergency powers, saw an exacerbation and proliferation of discriminatory policing, especially against racialised minorities, predominantly black people. The human rights charity Liberty said in 2020, during the coronavirus pandemic, the consequences of heavy-handed and uneven policing have been magnified, eroding trust in the authorities, putting our public health at risk, and leaving communities of colour over-policed and underprotected in the biggest public health crisis of a generation. Liberty stressed, however, that coronavirus did not create new problems such as to expose pre-existing inequalities. The discrimination exhibited in the use of police powers under lockdown follows the patterns being not just ignored, but reinforced within everyday UK policing. The Institute for Race Relations echoed liberty in September 2021. In its report, A Threat to Public Safety, Policing, Racism and the COVID-19 Pandemic, when it said, quote, "The COVID-19 pandemic ushered in a period of extraordinary police powers, which arrived in a broader context of racist over-policing and police violence. British society was already on a trajectory towards increasingly punitive social order. With policing at its heart, the pandemic became a vehicle through which this trajectory was articulated and accelerated. For a punitive state, policing the pandemic was but a logical solution to a serious problem. But this is not to say that it was an appropriate solution." Set in its socio-political context, scholars have argued the pandemic revealed the neglect and withdrawal of the state in all other functions but punitive. The state could not distribute masks for nurses, but retained an incredibly well-resourced, militarized police force. Let's take, for example, fines, known as fixed penalty notices, given to the public for alleged breaches of the coronavirus regulations and the 2020 Act. An investigation by Liberty in May 2020 found that between the 27th of March and the 11th of May 2020, which was prior to the Black Lives Matter protests, English police forces handed out 13,445 fines, for which black people were 54% more likely to receive. In fact, the first conviction under the 2020 Act was against a black woman, Marie Deneau, which was quickly exposed as unlawful. The Joint Committee on Human Rights report in April 2021 on the government response to the COVID-19 fixed penalty notices, noting the figures by the NPCC, said that despite Asian people making up 7.5% of the population, they represent 13% of those issued with fines. And where black people make up 3.3% of the population, we make up 8% of those fined. The report went on to say, the NPCC conducted a review into the potential disproportionality in July 2020. This found that people from all BAME backgrounds were issued with fixed penalty notices at a rate of 4.0 per 10,000 of the population, compared to 2.5 per 10,000 of the population for white people. Fixed penalty notices were issued to black and Asian people at a rate of 1.8 times higher than white people. The review compared this disparity to stop and search, where black people were 9.7 times, let me repeat that, 10 times more likely to be stopped than white people. This comparison is not comforting in a context where we are criminalising what would otherwise be everyday behaviours. Any disparity is deeply problematic. This takes me to stop and search. Stop and search practices surged, with stop and search rates more than doubling in May 2020 compared with the previous year. Liberty found that in London, levels rose to their highest in over 7 years. The situation in 2021 has been no better. The most recent Home Office data suggests, and I say most recent because the Home Office was actually supposed to release more up-to-date statistics recently, but has failed to do so, which has been criticised widely as withheld to hide the rise of the discrimination in the light of the government's policing bill currently going through Parliament and its beaten crime plan, which both will vastly expand stop and search powers, especially suspicionless searches. This takes me on to the bill. The Police Crime Sentencing and Courts Bill. The proposals with the bill are, as I'm sure all of you would accept, be an affront to human rights and dignity on so many levels. Nonetheless, the Home Office quite recently had the audacity to acknowledge that although many of the bill's provisions could disproportionately affect ethnic minorities, they nonetheless are objectively justified. So, let's just stick with the theme of stop and search, which we know disproportionately affects black people. The bill proposes to introduce Serious Violence Reduction Orders, SVROs. In brief, courts will be expected to impose SVROs on any person aged 18 or over who has been convicted of an offence involving a bladed article or other offensive weapon, or who had such a weapon with them when the offence was committed, unless there is compelling reason not to. Police officers will then be granted powers to stop and search anyone subject to an SVRO, regardless of whether or not they had reasonable grounds to suspect they are carrying a weapon. The bill does not address what, if any, legal remedies will be available to those who are wrongly stopped and searched. But what is clear is that the power goes beyond that which we see under Section 60, suspicionless searches. As Professor Lee Bridges explains in the police bill, SVROs, and guilt by association, quote, while such suspicionless stops and searches can be authorised for use by police under what is known as Section 60, such authorisations are limited as to both time period and specific location where they can be used. By contrast, SVROs will last a minimum of 6 months and up to a maximum of 2 years, and they can be renewed and extended further on the application of the police. They can also be executed in any police area in the country. To give effect to this, those subject to SVROs will be legally required to notify the police in any area they move to or choose to reside for more than a month. And a failure to do so will in itself constitute a criminal offence punishable by up to 2 years in prison. As the Institute for Race Relations noted, this does not take us back even to the discriminatory culture within a non-diverse police force that existed pre-Macpherson. It takes us back to 1981 and the saturation of colonial-style policing that led to the Brixton uprisings, which even Lord Scarman, who carried out the official inquiry, characterised as unwise. Leabridges further highlights that SVROs continue a long history of black people being guilty by association, most notably in the joint enterprise cases. As he notes, the bill, quote, allows for an SVRO to be made in respect of any person aged 18 or over who is convicted of an offence, not necessarily one involving his or her own use or possession of a bladed article or other offensive weapon, but who is found on a balance of probabilities to have known or ought to have known that another person would use or be in possession of such a weapon in the commission of an offence. Effectively then, the government is proposing that the concept of foresight, discarded after Crown against Jogi, should be revived as a means of imposing SVROs on secondary parties caught up in situations where knives and other offensive weapons have been used or possessed by others in the commission of an offence. Even though these secondary parties may have been acquitted in joint enterprise proceedings of responsibility for the main offence, or not prosecuted at all, so long as they have been convicted of some other offence, not necessarily involving their own use or carriage of a knife or other offensive weapon, they could still be made the subject of an SVRO. Moreover, the bill provides not only that the courts can impose SVROs on the basis of proof on a balance of probabilities, but it can also take account of evidence that would have been inadmissible in the criminal proceedings in which the offender was originally convicted. The latter provision opens the door for the police and the prosecution to use various forms of hearsay, so-called intelligence, which might have been excluded from the original criminal trial as a means of justifying the imposition of an SVRO. Also, unlike the current Section 60 powers, which require prior authorization from a senior ranking officer, powers under the bill require effectively any officer to use the power against someone who has an SVRO. But fear not, the government obviously hasn't left out Section 60 searches. Under its new Beat the Crime plan, the government will permanently relax the best use of stop and search scheme, BUS, which stipulates powers can only be triggered by a high-ranking officer in exceptional circumstances. As a result, lower-ranking officers will be able to use the power, and many of the strict requirements will now be relaxed. This is very concerning, as Section 60, as it currently stands, already disproportionately affects black people. Liberty noted that the Metropolitan Police issued 65 Section 60 orders in May 2020 alone. They stopped 1,418 people under the power. more than double the number of people stopped in May 2019, and far higher than any other month this year. Under the current Section 60 powers, black people are already 18 times more likely than white people to be the subject of the power. Yet, around only 1% of these stops result in weapons being found. Many law and human rights charities are currently challenging the use of Section 60 powers. For example, the Criminal Justice Alliance launched a super compliant calling for the power to be repealed. Following the Beating the Crime Plan announcement, the Criminal Justice Alliance wrote an open letter to the Home Secretary and submitted a Freedom of Information request calling for the evidence behind the decision to relax the conditions around Section 60. 3 months later, they are still awaiting a response. Separately, campaigners including the Criminal Justice Alliance, Liberty and Stopwatch have now launched a legal action against the plan to relax the safeguards under Section 60 after the Home Secretary did not respond to a pre-action letter sent in September of this year. Challenging the government through the courts is all well and good. I mean, I would say that. It's my job. But we must be realistic about the prospects of such an action. And this is in no way to be defeatist. As Professor Jennifer Eberhardt pointed out in her book, Biased, quote, the same disparities that community leaders view as proof of racial profiling can be cited by police officers as proof of who is most likely to commit the crimes. End of quote. But this doesn't just seem to be the populist position. It appears to be affecting the most senior judiciary across the globe. The US Supreme Court decisions such as McCleskey against Kemp in 1987 declared that racial sentencing disparities are an inevitable part of our criminal justice system. And in Wren against the United States, 1996, which effectively authorised racially motivated traffic stops. But the UK appears just as laissez-faire about the situation, not only recognising the disproportionate practices, but somewhat condoning them for the better good of black people. For instance, on the issue of suspicionless search, Lady Hale, yes, Lady Hale, said in 2015 in the case of Roberts against the Commissioner of Police of the Metropolis, quote, the purpose of any random suspicionless power of stop and search is to reduce the risk of serious violence where knives and other offensive weapons are used, especially that associated with gangs and large crowds. It must be borne in mind that many of these gangs are largely composed of young people from black and minority ethnic groups. While there is a concern that members of these groups should not be disproportionately targeted, it is members of these groups who will benefit most from the reduction in violence, serious injury and death that may result from the use of such powers. Put bluntly, it is mostly young black lives which will be saved if there is less gang violence in London and some other cities. End of quote. It is with this pretext from Lady Hale herself that I fear the courts will truly understand the issue before them. Let's move on to protesting, where although in the last year the courts have handed down multiple judgments in support of the right to protest, racialised policing has always been a particular problem. BLM and protests. The difference in treatment of black people by the police was again cast into stark relief by the police response to the Black Lives Matter protests in the summer of 2020 in the UK. On the 6th of June 2020, we saw mounted police officers seemingly charge protesters. Meanwhile, other protesters, including young teenagers, were kettled on numerous occasions, even into the early hour of the morning, without food and drink. And when police began to contemplate releasing people from the kettle, legal observers reported to the Network for Police Monitoring, NETPOL, that this was initially on the condition that individuals had images taken of them. This was in direct contravention to a High Court ruling which makes it clear that compelling someone to submit to recording is unlawful. Similarly, people were reportedly told that they had to provide their names and addresses, even though the only lawful basis to require this is where there are reasonable grounds to believe that the individual whose details are being taken is or has been engaged in anti-social behaviour. The police were consistently criticised for having one rule for them and another for us, and for flagrantly disregarding the health of others by refusing to wear masks. A contributor to the Institute of Race Relations' recent report on racism and the pandemic said on the BLM protests, and also the Kill the Bill protests, that, quote, the whole irony of it and the whole illogic of it is the fact that obviously breach of the COVID regs is inherently meant to be a public health response. And it's just completely illogical for them. A public health response involves like sending 40 to 100 police officers into an area, kettling people, using pepper spray, and then putting loads of people in police stations and in custody, where obviously the risk of transmission is going to be higher. So it's just so obvious to us that this has got nothing to do with public health. This is just about the police being able to shut down protests. That's the reality of it, because if it was a genuine public health response, then what they are doing right now wouldn't make any sense. End of quote. The director of the Institute for Race Relations, Liz Fekete, said in a report in the IRR in September 2021, a report on policing, racism and the pandemic, quote, this research gives a voice to those who've had uncivil, discriminatory or brutal encounters with the police and points to the dangers that the public health model poses for policing by consent. The evidence of the over-police reveals that those who argue that mistrust of the police is based on hearsay, myth-making and victim mentality are hopelessly out of touch. End of quote. The Home Office Affairs Committee said in July of this year, in its 22 years on from the Macpherson report, we call for urgent action to tackle deep-rooted and persistent racial disparities in policing. The central aim of the 70 recommendations published by Macpherson was to eliminate racist prejudice and disadvantage and demonstrate fairness in aspects of policing. More than 2 decades later, this aim has still not been met. Let's pause and think about the Macpherson report for a moment. For its significance of bringing to the British shores a concept of institutional racism in a scathing report condemned by the police, a bungled investigation into what was clearly a racially motivated attack. The issue of racial violence and the police inability or willingness to investigate is still a matter of serious public concern. Take, instance, recent stats. Firstly, racially motivated crimes account for nearly 3/4 of the total number of 124,000 hate crimes reported in the year ending March 2021. An increase of 12% over the year, Home Office data shows. While similar data from 2019 found that the police were failing to identify suspects for almost half of racially and religiously aggravated attacks in parts of the UK. Secondly, from 1999 to 2014, there were at least 93 deaths with a known or suspected racial element. And despite 84% of cases resulting in a murder, though not necessarily murder or manslaughter, only in 1/4 of these cases were allegations of racism accepted and prosecuted. Use of force. Hand in hand with issues previously mentioned is the state's own use of force, for which ethnic minorities, particularly black men, are disproportionately affected by. In 2019-2020, black people were 5 times as likely to have force used against them by the police as white people were subject to. And in relation to the use of tasers, 7 times more likely than white people. Between April and June 2020, there was a 12.5% increase in the recorded use of force across England and Wales, with racial minorities disproportionately being subject to it. For instance, over the same time period, 38% of the Met's use of force was targeted as black people, who make up only 13% of London's population. In August, the IOPC, Independent Office of Police Conduct, published a review of cases involving the use of tasers between 2015 and 2020, which also offered critical findings on the continual disproportionate prolonged use of tasers against black people. As the charity Inquest noted in its submission to the UN High Commission inquiry into police brutality and black people, quote, "At the sharp end of this continuum of racialized state harm and violence is the disproportionate number of black people who die after the use of lethal force and neglect by the state." The 2017 Angelini review on death and serious incidents in police custody had this to say on deaths in custody in black people, which I can note was commissioned by the then Prime Minister Theresa May. Quote, "The stereotyping of young black men as dangerous, violent and volatile is a long-standing trope that is ingrained in the minds of many in our society. It is not uncommon to hear comments from police officers about a young black man having superhuman strength or being impervious to pain, and often wholly inaccurately as the biggest man I've ever seen or encountered. Such perceptions increase the likelihood of force and restraint being used against an individual who may be unwell. The detainee is effectively dehumanised. In such circumstances, the police officers may also use force and restraint in order to gain compliance, to the exclusion of any focus on well-being of the detainee, which can ultimately lead to a medical crisis and death. As Akala said, it is usually taken for granted by those it protects that the absence of rightness can literally be the difference between life and death. Deaths in custody. Despite black people only making up 3% of the population, the IOPC's 2021 data shows that black people are most likely to die following or during police contact in England and Wales, making up 10% of cases. The IOPC previous data for 2004 to 2020 is similar. 18.6% of fatal shootings were black people, 11.6% Asian, 8.3% of deaths following police contact were black, 3.2% Asian. 7.4% of road traffic incidents resulting in fatalities were black people, 8.9% Asian. 3.3% of apparent suicides following police custody are black, 3.67% Asian. Other deaths following police contact, 6.38% are black, 5.92% Asian. Analysis of inquest casework and monitoring found that ethnic minorities generally die disproportionately as a result of force or restraint by police. The proportion of ethnic minorities in custody where restraint is a feature is now 2 times greater than in any other death in custody. The proportion of ethnic minority deaths in custody where the use of force is a feature is over 2 times greater than it is in other deaths in custody. The proportion of ethnic minority deaths in custody where mental health related issues are a feature is nearly 2 times greater than other deaths in custody. Accountability. In July 2021, the United Nations High Commissioner on Human Rights, Michelle Bachelet, published a damning report calling on states, including the UK, to end impunity for human rights violations against black people by police officers and to reverse the cultures of denial towards systemic racism, particularly in the context of policing and deaths in custody. I pause there and interpose. It says something that even the head of the Metropolitan Police cannot accept or thinks it's unhelpful to describe the Metropolitan Police suffering from institutional racism. But our country has a shocking track record for holding on-duty state agents to account for the deaths of any person, regardless of their race. As David Allen Green said, referring to a raft of legislation designed to grant effective immunity for extrajudicial killings, including covert human intelligence sources, Criminal Conduct Act 2021, the Overseas Operation Act, and most recently the Nationality and Borders Bill, quote, the UK government generally want to be as free as possible from any legal consequences when its agents cause death. Statute by statute, the trend is for the British state to remove any relevant criminal or civil liability from those who make life or death decisions in its name. This must, of course, be considered within the wider context of a government trying to extricate themselves from its obligation under the Human Rights Act and Strasbourg jurisprudence, as well as the government's assault on judicial review. Until the very recent conviction of PC Benjamin Monk for the manslaughter of the former Aston Villa footballer Dalian Atkinson, there had not been any successful prosecution for murder, manslaughter, or other related charge of any police officer in relation to any death in custody or after police contact for more than 35 years. One of the first known successful prosecutions of a police officer regarding the death of custody was in 1971, where Inspector Geoffrey Elliker and Sergeant Kenneth Kitchen were convicted of several assault charges in relation to the death in custody of David Olawale in 1969. After this case, there appears to have been no successful prosecution until 15 years later, when in 1986, where Sergeant Alwyn Sawyer was convicted for the manslaughter of Henry Foley in his custody, and for the next 35 years until the case of Monk. Monitoring by the charity inquest has found that, separate to the above three convictions, at least 2 police officers since 1990 have been found guilty of breaking health and safety laws relating to the unlawful killing, but no individual was successfully prosecuted for the killings directly. At least 1 police officer was found guilty of misconduct in public office for failing to check on a man who had killed himself while in custody. However, since 1990, inquest has found that there have been at least 9 unlawful killing conclusions returned by juries at inquests into deaths involving the police, and 1 unlawful killing finding by a public inquiry into a shooting, as well as other critical findings of use of force, none of which have resulted in successful murders or manslaughter prosecutions. Most recently, the Met police officer Dinesh Jaffer, 47, and Jamie Lewis, 33, pleaded guilty to charges of misconduct in public office over the murder of Biba Henry and Nicole Smallman, 2 black women who were stabbed to death in northwest London, in a northwest London park in June 2020. The officers took selfies next to the women's body, superimposed their faces onto the body and shared them on WhatsApp with other officers. They await sentencing. Sexism. But the issue of abuse of power by officers and brutal violence and the lack of accountability is much wider than just race. It touches on several institutional forms of oppression, which have been allowed to fester for years, including sexism, misogyny, and race, but to name a few. The Police Action Lawyers Group captured the issue quite neatly in a statement following the murder of Sarah Everard by police officer Wayne Cousins, as well as the murder of Biba Henry and Nicole Smallman, and the Met's conduct. The statement said, "We have and continue to represent thousands of women and girls who have been wrongly detained and or assaulted by police, who have been spied on and deceived by police, who have reported exploitation, violence and sexual assaults to the police, only to be dismissed, and women who have been mistreated by a criminal justice system which does not seem capable of accommodating their needs. We also represent families of women and girls who were murdered by men following police inaction, who died in custody because of poor care. The threads running through all of these cases and through every police force we litigate against are endemic misogyny and casual sexism, more often than not compounded by other forms of discrimination, race, disability, sexual orientation, etc. Nowhere is this more graphically demonstrated than in the police behaviour following the murder of 2 black women, Biba Henry and Nicole Smallman. Denise Uger, Deputy Director of the End Violence Against Women Coalition, said, "The IOPC explanation for the Met's failure is frankly insulting and shows an unwillingness to ask themselves the difficult questions needed to really root out racism and misogyny within their ranks." And multiple former chiefs of police also insist that bias played a part in how the police dealt with the investigation. Sue Fish, the former Chief Constable of Nottinghamshire, said that bias had been a factor. Quote, "I see plenty of bias. The IOPC report gives license to continue to fail people of colour and women of colour into the future. It does not have a finding of racism. It addresses things in performance terms and misses everyday casual unconscious biases against people of colour and women." Former Met Police Superintendent Dal Babu said, if this had been a white, middle-class social worker, the police would have dealt with it differently. I'm convinced they would have done. Former Met Chief Superintendent Victor Olisa, a former head of diversity at the force, said, "I think there is bias. I know the investigation of missing persons is not as professional as it ought to be." Recent cases and statistics bear out these charges that the police failed to investigate gender-based violence. For example, 27th of October, a Metropolitan Police officer was charged with rape. PC Adam Zaman, 28, has been remanded into custody. Currently, another officer from the Metropolitan Police, James Jigongan, 27, is on trial for rape. Alleged abuse of position for sexual purposes is the single largest form of police corruption that IOPC deals with, accounting for around a quarter of all corruption referrals last year, and almost 60% of corruption investigations, according to the police watchdog. Can you believe that? The End Violence Against Women Coalition reported, citing other sources, that at least 15 serving or former police officers have killed women since 2009. Over 750 Met Police employees, including officers and staff, have faced sexual misconduct allegations since 2010, yet only 83 were sacked. One woman a week reports domestic abuse by a police officer, and a super complaint highlighted systemic failures to hold officers accountable. Only last week, a letter before action, the first step in the judicial review proceedings, was sent to the Home Secretary, Priti Patel, by the Centre for Women's Justice for her failure to take urgent steps to tackle police-perpetrated abuse. The letter calls for Patel to, amongst other things, 1, convert the inquiry to a statutory one by exercising the powers under the Inquiries Act 2005, 2, to commit to expanding the scope of the inquiry so that it's not focused only on one officer, Wayne Couzens, but to address police perpetrated abuse and violence against women more generally, and 3, to commit to ensuring it will address key issues concerning the experience of black and minoritized ethnic women and women with disabilities. Another recent and notable example of the court's unequivocal denouncing of the action of officers against women was the Investigatory Powers Tribunal ruling in Wilson against the Commissioner of the Metropolitan Police and NPCC regarding the undercover policing operations. The tribunal found a formidable list of breaches of the ECHR by the Metropolitan Police, including inhuman and degrading treatment, sexist discrimination and interference with the right to hold political opinions and freely express oneself. The tribunal said, quote, "This is not just a case about a renegade officer who took advantage of his undercover deployment to indulge his sexual proclivities. Our finding that the authorization under RIPA, the Regulation of Investigation Powers Act, was fatally flawed, and the undercover operation could not not be justified as necessary in a democratic society, reveal disturbing and lamentable failings at the most fundamental levels. So, where are we from here? When it's clear it's not only the state willing to fundamentally breach our human rights, but then makes no qualms about deliberately frustrating investigations and circumventing accountability and insisting on a culture of denial. How do we achieve accountability for black people? What are the solutions? The cynic would say the solutions are limited, for history shows that racism will continue to prevail. However, Professor Patricia Williams said, quote, "The solution to racism lies in our ability to see its ubiquity, but not to concede its inevitability. It lies in the collective and institutional power to make change, at least as such as with the individual will to change. It also lies in an absolute moral imperative to break the childish, deadly circularity for centuries of blindness to the shimmering brilliance of our common and ordinary humanity." So, what about the justice system, the judiciary, the professionals? Can they help? Well, they could and they should. In fact, they must. But critical legal theorists, including feminists, critical race and queer theorists, have long stressed the inbuilt bias within law, from the substantive legal rules and provisions to the form through which the law, through justice system institutions, including state agencies and judicial processes, disciplines its subjects. Such critics, and rightly so, challenge the widely held presumption that the law, including human rights law, is neutral, instead positing that discourse on law and human rights alongside discourse on race must be viewed in its historical context, in which Western ideas are being consolidated, particularly about rights and minorities. Accordingly, many argue that anti-discrimination legislation does not effectively oppose and combat racism because it fails to understand the nature of racism. It is interpreted by judges who too fail to understand the experience of racism, and because the racism that pervades our society also pervades our legal system, may be uncovered in an analytical approaches to judicial decisions. The Lamy Review in 2017 confirms this in its findings that differential treatment of people of colour occurs at all levels of our legal system. Differential and unfavourable treatment in its encounters with the police, decisions as to whether to charge or not, bail or not, in the way that we are prosecuted, the way that we are sentenced, the types of sentence, the length of our sentences, our treatment in prisons, how we're disciplined in prisons, whether we're granted parole or not. So, how do we ensure that our judges, particularly our senior judiciary, have due regard to racial justice and help champion its progress, especially bearing in mind that in the last 10 years, the proportion of black judges has increased very little, and in the past 10 years from 0.7% to 1%. We've seen that the way our land's highest courts deal with racial profiling in the case of Roberts. I've given you the example. Abimbola Johnson, a barrister at 25 Bedford Row, says, "The majority of lawyers are white middle class. That whiteness and class background informs the base culture of what we do. Many in the profession mostly come from members of the black community in the courtrooms. It's a fallacy to suppose that negative views and assumptions will not find their way into our work unless we consciously make sure they do not. As practitioners, we must make sure that we are not applying only white middle class expectations of behaviour on citizens that are anything but that. I must agree. And sadly, since Miss Johnson's words of the last 12 months, there have been damning reports charging our profession with itself as a breeding ground for bullying, harassment, discrimination against ethnic minorities. And guess who's at the bottom of the pile? Black women. As expected, the situation is the most pronounced, the most hostile for those who sit at the intersection of race and gender. As I say, black women. Just think about it. If we as a professional people can be treated in this way, in a so-called well-respected profession, it takes very little imagination to think how defendants of African heritage are treated by the police and the wider justice system, including by lawyers. The solution. The potential solution to racial inequality are complex. And so too, when considered that the justice system of treating black people. In short, as I've addressed in many other keynote speeches that I've given recently, the legal profession, including lawyers and judges, must first of all be committed to diversity. Not for the sake of diversity, but for its improving of decision making, as well as its ability to improve the trust and confidence in communities they serve. But most importantly, at the heart of the solution is anti-racism. A simple solution, I know. But seriously, I've spoken at several events as to what is needed and what is expected from all of us in terms of adopting an anti-racist position. Becoming an anti-racist, I say, is the most fundamental for those of us who have a role to play in the justice system, whether that be as lawyers, judges, academics, regulators, students, as well as, of course, state agencies and their respective watchdogs. But in brief, let's take the judiciary. Where the challenge may be most difficult, what a judge adopting an anti-racist practice will look like? Well, I've trawled through UK cases hoping to find something better than Lady Hale. I had to go to the US, and I have a quote, and I've used it a couple of times in recent talks I've given, but it is unbelievably relevant and was handed down in a case not long after George Floyd's death. And this is how it goes. Clarence Jameson wasn't jaywalking. That was Michael Brown. He wasn't playing outside with a toy gun. That was 12-year Tamir Rice. He didn't look like a suspicious person. That was Elijah McClain. He wasn't suspected of selling loose, untaxed cigarettes. That was Eric Garner. He wasn't suspected of passing a counterfeit $20 bill. That was George Floyd. He didn't look like anyone suspected of a crime. That was Philando Castile and Tony McDade. He wasn't mentally ill and in need of help. That was Jason Harrison. He wasn't assisting an autistic patient who had wandered away from a group home. No, that was Charles Kinsey. He wasn't walking home from school. No, that was 17-year-old James Earl Green. He wasn't walking back from a restaurant. That was Ben Brown. He wasn't hanging out on a college campus. That was Philip Gibbs. He wasn't standing outside his apartment. That was Amando Diallo. He wasn't standing inside his apartment eating ice cream. That was Botham Jean. He wasn't sleeping in his bed. That was Breonna Taylor. He wasn't sleeping in his car. That was Rayshard Brooks. He didn't make an improper lane change. That was Sandra Bland. He didn't have a broken tail light. That was Walter Scott. He wasn't driving over the speed limit. That was Hannah Pfizer. He wasn't driving under the speed limit. That was Ace Perry. No, Clarence Jameson was a black man driving a Mercedes convertible. Thankfully, Jameson left the stop with his life. Too many others have not. These were the first 20 lines of US District Judge Carlton W. Reeves in August 2020 in the case of Jameson against McLennan regarding qualified immunity of the police to certain claims of wrongdoing. Judge Reeves just so happens to be a black man. Let me finish with this. A poem by Edgar Albert Guest. Someone said it couldn't be done, but he with a chuckle replied that maybe it couldn't, but he would be one who wouldn't say so till he tried. So he buckled right in with a trace of a grin. If you worried, he really hid it. He started to sing as he tackled the thing that couldn't be done, and he did it. Someone scoffed, "Oh, you'll never do that. At least no one's ever done it." But he took off his coat, and he took off his hat, and the first thing we knew, he'd begun it. With a lift of his chin and a bit of a grin, without any doubting or quit it, he started to sing as he tackled the thing that couldn't be done, and he did it. There be thousands to tell you it cannot be done. There will be thousands to prophesize failure. There be thousands to point out to you one by one the dangers that wait to assail you. But just buckle in with a bit of a grin. Just take off your coat and go to it. Just start to sing as you tackle the thing that cannot be done. And we'll do it. Thank you.
Thank you so much, Leslie, from the depths of our heart for such devastating, grim certainly, but then inspirational too, especially those last couple of pages, the poem you read, the quotation from that American judgment. They speak to what your work is bringing to us here at Goldsmiths. That unique driving force for change, even when the odds are against you. We're very thankful for that. We only have a few minutes, so I won't take more of our time. The floor is yours now for questions, reactions, comments, thoughts, feelings. Would like to come in. It was a thrilling account, but please.
Firstly, thank you so much. That was really illuminating. One of the themes that you brought out was that the UK government is trying its best to increase its powers to police the population. And I was wondering how the development of new technologies, facial recognition, which is being used by the police and in schools, is going to change or exacerbate the underlying biases that already plague our justice system.
I think you're going to see an increase in litigation. It's not just the facial recognition, it's all sorts of artificial intelligence and algorithms. There's a really interesting group who have been championing the rights, trying to challenge some of these, this new tech. I don't know if you remember last summer with the exam debacle, the A-level debacle following COVID, the problems with that and how some of these algorithms single out and have implied biases in them. And if you've got, and that was recognised, and if you've got them on that level in terms of schools and populations, I can tell you this now, you've got them on many other levels, and they certainly are racialised. I gave a talk at GCHQ about government spy centre about 6 months ago, and they wanted to talk about how great they are, sort of like protecting us and having all this new advanced tech to keep us safe from terrorism. And I asked them one question. So, what safeguards do you have to ensure that the algorithms don't have implicit biases and prejudices? Oh, we've got, and they came out blah, 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 blah. I said, yeah, but who is checking it? What do they look like? How many black people do you have working? And it was like, heads down looking at their feet. And they know they've got a problem. But as I was indicating in the talk, the emphasis is, well, we'll sort those problems out later. Let's keep us safe. Let's keep us safe from COVID. It's a big problem. I don't know what the answers are. I think what we need to do is be vigilant.
And to your point, the people behind the algorithms aren't a diverse pool of people. So they don't engage with it, and the tech specialists are not thinking in that way. You talked about anti-racist, being anti-racist, being actively anti-racist, and taking the judiciary, for example. How do we begin to engage people who aren't affected by this at all, so don't engage in the conversation? I'm just going to look around of faces. So they're not impacted and affected. They don't come to these spaces, they don't open their minds, and they don't need to, because they lived a comfortable, privileged life.
Yeah, you're right. I find that when I talk, I'm talking to friends and allies. Yeah, and so I'm talking to people who are progressive, who want to be progressive. I gave a talk. And you can see this talk if you're interested. Just Google the Inner Temple Readers Lecture that I did in February of this year. Right. So if you go, it's on YouTube. But if you Google Leslie Thomas Inner Temple Readers Lecture, and I went in the Inner Temple. I'm a member of the Inner Temple. Right. They invited me to give a talk, one of their readers' lectures, and so I gave it on how to be an anti-racist lawyer. Interestingly, the audience are the people who you wouldn't get here, and they were shocked because I didn't hold back. I let them have it with both barrels. You need to look at yourselves. And so they heard the message, they are repeating the message is out there. The question is, what do they do with the message? My mum used to say to me, you can take a horse to water, but you can't force it to drink. And I think that is where we're at. How do we persuade, convince people that they need to take a look at themselves? Do you remember the clip that I started with Toni Morrison? There's a part in it where she says, it's white people who need to realise that they need to look at themselves. And she's right. Because as a black person, I can be shouting from the rooftops, but I'm not going to change the situation. I don't have the power to change the situation for other black people. It's when white people realise and are invested in it. And the question is, how do we get our brothers and sisters who are white to be invested in this issue? And you know, I'm just going to go around evangelising as much as I can to see if I can get people on board. But you're right.
Thank you, Professor. My second question, just to commend you. Somebody like me, to be honest, when it comes to race issue, I have stopped talking about it because I've given up. But it appears that the last poll appears to give me a little hope. I don't know whether it is hope that is going to carry me.
It's a lovely poem. Edgar Albert Guest.
Right.
Edgar Albert Guest. Right. It couldn't be done.
Okay, because I have looked from America to UK and obviously across Europe. And one question I keep asking myself, why does the West keep preaching about human rights? Is it human rights for one section, race? No. Because there is no way America, UK should preach human rights to third world countries and other countries. Look at America. When the policeman wants to talk to a black man, first thing he has his hand on his gun. And yet you talk to me about human rights. Do blacks have rights, or do minority have rights?
I mean, so you're not asking questions. You're making some very valid comments. There's a really interesting series on Netflix. Has anybody seen Colin in Black and White? Really interesting. Colin Kaepernick, highlighting his high school years. Really interesting. The one where he is, I didn't realise that Colin Kaepernick was adopted by two white parents. And there's a part in that show where he is driving for the first time. And he's driving to a college basketball or football game. And he gets stopped. And the first thing that, and what you see is in the weeks leading up to his stop, his dad's driving, and he passes many police officers, and they don't even stop him, they just wave him on. And the first time that Colin drives, he gets stopped, and the officer comes up to him and says, "Put your hands on the wheel." And he goes, "Right, show me your license." He goes to his license, and the officer pulls out his gun. And it just goes to show that when you're in black skin, just how our lives are threatened. And the officer turns to his parents who are in the car and say, "Are you folks all right?" Not realising that this is their son. You had a question?
I wondered, just in terms of the point that the question that was asked before that gentleman about how to engage people who aren't affected, do you think that can come by reform of the current system that we're in and having black people in positions of power, more black people in positions of power and influence, or will it require a radical overthrowing of the system?
This system is not going to be radically overthrown. If you're asking me what my desires and what my wishes would be, I would want this system to be completely started from scratch. But that ain't going to happen. The one thing is, I'm a realist, and so in terms of what we can do to get into positions of influence and power, I think, yeah. Now let me ask somebody else, and then I'll come back to you.
Personal question. So it overlaps with what you just said effectively. So as a black practitioner, how do you reduce the effects of weathering when you are effectively evangelizing and having to deal with issues day by day, year by year, knockbacks, etc. And I say this as a fellow practitioner as well.
It's tiring.
Indeed it is.
It wears me down. I'm sick of it. I've got to the stage where I'm sick of the fact that I have to be seen as, a preacher for a cause. I'm sick of the fact that I just can't get on and do my job. Many of my white brothers and sisters can just do their job. They can just, they don't need to think about this shit. But I have to, and the reason why I do it? Because I've now realised, I know that I've got to a position where if I ain't doing it, who else is going to be doing it? I'm the first black professor of law at Gresham, and it's 400-year history. They've never had a black law professor ever in 400 years. If I don't do it, if I don't step up, who will? And I look at you, I look at the next generation who are coming up, and I feel I owe it to you in the same way that there were mentors and people that I looked up to who came before me, Rudy Narayan, Sibbat Kadri, Courtney Griffiths, these titans before me who eased the path, made it easier for me, and that's what happens. There will be more failures than successes in my attempts to do this, and I will be beaten down, and I'll be exhausted and tired. And
this gentleman talked about, do we need to have people of colour in positions of influence? If you take our government and current cabinet, on the face of it, in my lifetime, this looks like the most diverse, right? On the face of it. And yet their policies and what they stand for is so detrimental to society, and it's increasingly racist. So, and this is the issue, isn't it? We're talking about stuff like this more on the face of it. You've got lots of people of colour in government, more than we probably ever had before. And this gives an illusion that things are changing and things are progressive, but we should always be challenging, like you have today, brought to the fore the reality of what's going on. So I think it's just important to be mindful, because sometimes you can have a person of colour who has a completely different lived experience of the majority of the people of colour in the country, and so are saying something completely different, and almost like they're using their skin colour to have a mandate to just pass really racist policies. Please Patel?
Well, it's not just pretty. It's not just pretty in the government at the moment.
Rishi Sunak.
Yeah, but yeah. All right, I'm going to take one more question. Anyone?
Yeah, so I was just, you covered Sarah Everard and about the police abusing their power. And since that happened, we've seen the police come out and claim responsibility for such things. Has that filtered down to the complaints that black people have been, making for decades now?
No, and when you say we see the police come out and accept responsibility, they drag, kicking and screaming. No. This is not something that's going to be resolved in 5 minutes. This is the misogyny within the police is so deep rooted. It was interesting. I was listening to a number of police women who were talking about their experiences, and it's shocking, to the extent that one of the problems about policing is you need to have your back watched when you're on the street, and if you complain, did anybody see the series Small Axe? Did you see the one about Logan, the police officer, and when he was, I think he'd made a complaint or something, if I remember rightly, and he was on the street, and his backup never came, and so he was beaten up by a suspect. Well, that's the reality about policing. And that's the culture, and that's what needs to be broken. Anyway, look, I think we're going to have to leave it there. Sorry, Dimitrios, we've really gone over.
Quite the opposite. So that, as we were saying at the beginning, there could not have been a better way to kick off this series of public lectures. There is more to come, and a lot of connecting to do between these issues. Please join us for a glass of wine, where we can perhaps continue the discussion or discuss about other matters all together. But once again, thank you so much. Thank you.